Well, let's take you back now to one of our top stories of the day, which is watching what unfolded in the continuation of the Senzo Meyiwa murder trial. Linda Mnisi is watching that trial for us from Pretoria. He's in studio tonight, and we're also joined by legal expert Ulrich Roux. Linda, let me perhaps kick it off with you and talk about where things ended off in court. Very strong arguments being made there by advocate Mshololo on why she believes her client has been treated unfairly, especially with this late emergence of this docket 375.
Yes, indeed, Kathy. You'll remember that she's been sitting with this docket now for over 2 months, studying it after it emerged during cross-examination of the first state witness, Sergeant Thabo Mosia. Now, she's come back after perusing and studying that docket carefully with an application dealing specifically with irregularities that happened in this case. This application is an application for a special entry, saying that she wants the appeals court to note it down during these proceedings because it really did affect how her client pleaded. She says had she had this docket before her client pleaded, they probably would have pleaded differently. So she sees this as really denying her client, a fair trial, saying that, the state really had this docket for quite some time and they knew the contents. She went as far as delving into the extent of the evidence, saying that the state saying that this docket in fact has no bearing on the current trial is not true, because in that docket there are statements from the likes of Sergeant Thabo Mosia himself. He made a second statement, you'll remember, Kathy, and in that statement, Advocate Mshololo says Sergeant Thabo Mosia seems to be contradicting himself. Another piece of evidence that is there is statements from Brigadier Ndlovu. You'll remember Brigadier Ndlovu is the one that's said to have, arrived first at the scene and pointed out the pieces of evidence that Sergeant Thabo Mosia was supposed to collect. So she says to say this particular docket is immaterial and has no bearing on the current case is really untrue and, prejudices her client.
Ulrich, let me bring you in here. Was it inevitable that we would get to this point? Because already having a case dealing with two separate dockets that really say two very different things about what likely transpired on the night Senzo Meyiwa was killed was always going to bring up problems.
Hi, good evening, Kathy. Yes, certainly. The emergence of the second docket was always going to be a problem for the state. And the reason why I say that is that the state is not there to persecute a person beyond all reasonableness. They must take into consideration all evidence available to them, and all of that evidence must be disclosed to the defense before a trial starts. And that is in order for the accused person and his legal team to prepare adequately for a trial. They have the right to the content of the docket, and they have the right to see all of the evidence in the state's possession when the trial starts. The application for a special entry, though, is one which we do not see often during a trial taking place. And the reason for that is that it's normally brought at the conclusion of a trial, and when a matter is taken on appeal. The purpose of the application for special entry is to bring additional evidence to the attention of the appeal judges who hear the appeal. That was the argument that also preferred today and brought to the court's attention, and one would have to wait and see what the court makes of this. On the one hand, the accused person does have a constitutional right to a fair trial, and one could argue that the fact that the docket was not disclosed timeously infringes upon that right. But on the second hand, it could also be argued that this application for special entry should only have been brought after the conclusion of the trial and after a conviction has been secured by the state, and that the appeal judges hearing the appeal should in fact take cognizance of the second docket and all of the evidence contained in it. But certainly it is troublesome for the state that there are conflicting statements from what we've heard in court today contained in these two dockets. The accused person only needs to prove reasonable doubt in order to be acquitted. And certainly, if there are conflicting statements made by the same person in two different dockets, that could very well contribute to that doubt being created and the accused persons being acquitted or found not guilty at the end of the trial.
Linda, did the state have a response to that? Because, you know, Sergeant Thabo Mosia is one of the key witnesses that they've called up. Interestingly, we haven't been able to move much beyond this initial witness.
Well, the state, Kathy, is saying that it's a bit premature for Advocate Mshololo to bring this particular application, as, of course, they have not secured a conviction in this case. But they've also, gone back to the transcripts previously where it was revealed that while Advocate Mshololo says they were not furnished with the docket, in fact, her instructing attorney did know of the existence of this particular docket. But you'll remember that the argument previously by Advocate Mshololo, with this, together with the state, was that despite the fact that they knew about the existence of the docket, it was not furnished to them, so they couldn't adequately prepare for this trial. You'll remember also that these are issues that are dealt with prior to the pleading by the accused persons in any trial, really, Kathy. And she says because this was not discovered at that particular time, they violated their client's rights. And the state saying that they could have asked for this information at any stage of this particular trial. But Advocate Mshololo saying that it was their responsibility as the state to really make sure that they got all the information that they needed in order to prepare adequately for this trial.
Ulrich, I don't see the defense letting this one go quite easily. What are the scenarios that may unfold if they continue with this argument around the unfairness of the presentation of this docket when the trial had already gotten underway, and just how it would prejudice their clients?
Well, the application does not ask for the prosecution to be stopped. It does not ask for the trial to start afresh. It only asks for a special entry. And what that means is that it is then noted on the record, and it must be taken into consideration, firstly, when the judge makes a finding on the accused or the innocence of or guilt of the accused before court today, and then ultimately for it to become part of the record if an appeal is lodged against the finding of the court. So yes, I do think that they are going to use it to a large extent to try and create that doubt. The state's argument is that they have not adduced any evidence contained in the second docket, and that the only reason why it has been brought to the attention of the court is because it was mentioned during cross-examination by the state's first witness. So, that is the ultimate goal of defense attorneys, obviously, is to create doubt in the state's case. And one could expect the defense attorneys and defense advocates in this matter to certainly place a lot of emphasis on the fact that there are contradicting statements and that the state have not followed the correct procedure in this matter. It would have been a better strategy for the state to rather combine the two dockets and then to disclose all of the content of both dockets to the defense prior to the trial starting, because then all of these issues would have been ventilated prior to the trial, and it would have been part of the trial by using the correct procedure. But certainly one can expect the defense to really place a lot of emphasis on this. Remember, at the end of the day, the judge must always act in an objective, unbiased manner, and he must take these issues into consideration, even though the statements are not formally part of the state's case that they are presenting against the accused at this point in time.
All right, legal analyst Ulrich Roux, let me thank you for your time tonight. Linda, before I let you go, where is the court going to pick up tomorrow?
So the application is still continuing, Kathy, and we're likely to hear from instructing attorney Titi Tobani making his submissions about this particular application tomorrow. And we're expecting then a ruling. It's unclear if Judge Chipuya Maumela will make a ruling tomorrow, but it's expected tomorrow because also Sergeant Thabo Musia will also be back. We had an opportunity to speak to him briefly today, and he said after that surgery, he's now feeling so much better and is ready to proceed.
All right, Linda Mnisi, let's leave it there for tonight.